Due Process, recipient of 6 Mid-Atlantic Emmy Awards.
We were attacked, and we have the responsibility not only to punish those who committed the attack, but more important, to prevent future attacks.
At the Justice Department, he was the point man on counterterrorism until he left Washington for a seat on the Third Circuit Court of Appeals. But now Judge Michael Chertoff is making no apologies for his part in the anti-terrorism plan, as you'll see on this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
There's been no attack on American soil since 9/11. So are we winning the war on terrorism, or is it a losing battle long term? And in our attempt to be safe, just how big a price are we paying? In the delicate balance between security and civil rights, has federal policy gone too far? There is no one we would rather ask, no one more appropriate to answer than our only guest on this special edition of Due Process. I'm Raymond Brown, and today a rare chance for some candid conversation with an architect of those controversial anti-terrorism policies. Now, federal judge Michael Chertoff, back from the U.S. Department of Justice with a seat on the Third Circuit in his first sit-down interview since leaving D.C. But first, Sandy came to tell us just how often he's been at the heart of the big legal stories, first here in the state and then on the national scene.
Raymond, of course, there has been no bigger legal story than the aftermath of 9/11, both the criminal investigation into what happened and the effort to keep it from happening again. And on both, Mike Chertoff left his mark with, as we'll hear, a clear conscience, a conviction that the government's course was correct. But is he still as certain as he was more than 2 years ago when he sat before the Senate Judiciary Committee to defend the government's moves?
We face an extraordinary threat to our national security and the physical safety of the American people of a character that, at least in my lifetime, we have never faced before.
As Assistant Attorney General heading criminal prosecutions, it was Chertoff's job to track down the attackers.
We were attacked, and we have the responsibility not only to punish those who committed the attack, but more important, to prevent future attacks.
And as head of the Justice Department's 9/11 task force, that responsibility was in large part his. From the controversial roundups to the Patriot Act. And neither skeptical senators nor civil rights critics gave him pause.
Are we being aggressive and hard-nosed? You bet. But let me emphasize that every step that we have taken satisfies the Constitution and federal law as it existed both before and after September 11th.
November 2001, when the Judiciary Committee wanted answers from John Ashcroft, the Attorney General sent Mike Chertoff. And last June, it was that same committee who questioned him again before voting to confirm him for a seat on the Third Circuit. That move from justice to jurist might have seemed unlikely just 15 months before, when Mike Chertoff was last here on Due Process.
I can't imagine anything that would be more satisfying than what I'm doing now. And I really can't, imagine or think about or speculate about what I might want to do in 10 years or 20 years, if I wanted to be a judge or if I want to be in private practice. Those are things which are very remote from the kinds of things we have to deal with on a day-to-day basis.
He had been on the short list to chair the Securities and Exchange Commission, a nomination that may have been derailed by business interests in opposition to a prosecutor heading the SEC.
There is nobody in the state that's too powerful to escape the reach of the law.
And it was as a tough prosecutor going after corruption and organized crime that Chertoff earned his stripes. First with the U.S. Attorney in New York, then as the U.S. Attorney for New Jersey.
I think if you look at this indictment, you will also see charges that go to the very essence of what we mean when we talk about political corruption, the sale of office for money.
Michael Chertoff does New Jersey proud, he does Essex County proud, and we are very, very happy to have him here this evening. Ladies and gentlemen, please congratulate Judge Michael Chertoff.
So when Mike Chertoff came home this week, it was to the applause of a legal community that sees him as one of its stars.
And yet in Mr. Mulcahy's testimony, he says this was a constant occurrence.
Even during his years in private practice, Chertoff was tagged from time to time to head public probes. Investigations as different as the state Senate's hearings into racial profiling.
Yes or no, was it made clear at the meeting that this issue of racial profiling was a big problem for prosecutors in New Jersey?
And earlier, the U.S. Senate's inquiry into Whitewater, a role apparently not forgotten by the junior senator from New York, the one vote against his Third Circuit confirmation.
Shoshana, I told him you were eager to meet him.
But it is Chertoff's stint at the Justice Department that left the biggest imprint and raised the greatest uproar. Not that that's likely to matter to Mike Chertoff.
So help me God.
So help me God.
Congratulations.
As he told us 14 years ago when he first became U.S. Attorney.
You can't do this job if you're worrying about whether you're going to step on people's toes. For so long as I'm United States Attorney, the U.S. Attorney's Office will be guided by an unswerving commitment to equal justice under law in the service of the public.
It was Michael Chertoff's mantra back then as U.S. Attorney, more recently in D.C. and now on the federal appellate bench. A goal of even-handed justice, an indifference to stepping on toes, and count our toes among them. Judge Chertoff has warned us there are things he won't talk about. And Judge, at the risk of touching on one of those things right off the top, why would you leave one of the most powerful law enforcement jobs in the world when it was clear that there was still plenty to do in a war against terrorism, still far from one, and given what you told us about loving to be there and having really no interest in a judgeship?
Well, you know, it's not a lifetime job, nor should it be a lifetime job for any number of reasons. So when the opportunity arose to consider an opportunity to be on the federal bench, you have to really think about what you want to do with the rest of your life. And I have to say, Sandy, the events of the last couple of years really left a significant imprint on me. I felt what I had an opportunity to do was probably the most important thing I had done. And the idea of going back to private practice was much less attractive at that point than continuing in public service in another forum. The other thing which made a big impression over the last couple of years was my traveling around, which emphasized the importance of the rule of law. All over the world, from Europe to Asia, people are coming to appreciate that the fundamental element of any free society and any democratic society is a commitment to the rule of law. And part of that is having an independent judiciary and people who are willing to devote themselves to a fair and even-handed application of legal principles. So, given the opportunity to play a role in public service in that capacity, it was, at that particular moment, seemed like the right thing to do, and I have to say I've not regretted it at all.
Were you burned out by what you had to deal with post 9/11? And what about the speculation that policy and or personality issues came into play in your decision to leave?
Well, first of all, I was not burned out. I mean, it is clearly a very intense job. It's an 18-hour-a-day job, and a job in which at any given moment you can face a tremendous emergency. But I can't say that I was burned out, and I certainly emphatically reject the idea there was any policy or personal issue. This was not a case of my leaving the Department of Justice. It was a case of the President having decided he wanted to nominate me and my being privileged to accept that nomination.
Since you mentioned the rule of law, which has always been at the core of your life and will be going forward, let me focus on an aspect of the rule of law where this administration has been very much criticized, that is international law. And a particular question, almost for all of the last century by law, and probably for custom going back centuries, there's been a concept that an enemy combatant captured would be held until the duration of the war. But this is an administration that's held large numbers of enemy combatants, and it's done so in the context of a war that it says might not end for the foreseeable future, raising an interesting problem about whether this nation is perceived as continuing to adhere to the rule of law with respect to international matters where the whole world is watching us.
Well, I actually think that the country has adhered to the rule of law. And as I think you made clear at the outset of this question, you're entitled to hold enemy combatants as long as the war is ongoing. And the Supreme Court has held that in a series of cases going back 100 years or so. And the problem with the war in this case is not that we are protracting the war, it's that the enemy is protracting the war. So for as long as the enemy is at war with us, we have a right under international law to hold enemy combatants and incapacitate them.
But to the extent that law is thought of as a restraint on power, we have a war that could be fought in Afghanistan one year and turn up in the Philippines another year while there's relative peace in Afghanistan and still be termed the war on terror. And so there's going to be tremendous power in Washington and the executive branch to kind of define it, leaving open the question of whether we really are adhering to rules that say there are limits to how long people may be detained, and it's a source of much criticism around the world.
Well, again, I don't know that there's a legal rule about how long a war lasts. I remember...
But I'm saying the lack of a rule would seem to give an awful lot of power to one group of persons running the executive branch of this government, and that might raise and has raised significant criticism around the world.
Well, again, from an international standpoint, and you think back to the 100 Years' War, which of course occurred a long time ago, wars continue for a long time on some occasions. And I think in this case, again, we did not choose this war. We didn't choose to begin it, and we haven't chosen to continue it. That choice has been made by people who really are the worst kind of combatants because they violate all rules of law. So I don't think that the position the government has taken here is in any sense inconsistent with international law. Now, international law is a funny thing because unlike what we're used to in this country where we have a written constitution and statutes and courts and a legislature, international law develops often through what they call custom. And custom comes from a lot of sources. And of course, different people have different senses of what the custom ought to be. So you can always find somebody who can point to some academic somewhere in the world who's going to have a view of international law that may be different from our own. But I think if you look at the mainstream way in which international law has applied to war, I don't think the United States has been out of step with what accepted principles are.
And yet you, Judge, would seem to have had this area of enemy combatants as one that you are willing to rethink. If I understood you in an article that you wrote in the Weekly Standard, you say that we need to debate a long-term and sustainable architecture for the process of determining when, why, and for how long someone may be detained as an enemy combatant and what judicial review should be available. That sounds to me like perhaps this is one area where you are second-guessing?
Well, no, it's not an area where I second guessed. I think what I was driving at in the article, and of course it was written before the Supreme Court took the pending cases involving the detainees in Guantanamo and Hamdi, was that these matters are now working through the courts. And of course the courts are going to set certain parameters down for how we deal with these issues. But as you can see from some of the decisions, Congress often plays a role in terms of how we address issues of war and how war is conducted. A lot of people have different ideas about the appropriate way to handle enemy combatants. And rather than simply sit back and let the court make the final decision and not have any input, I raised the question whether Congress or other interested people ought to begin to debate what the principles should be going forward in terms of enemy combatants. That's not to say that what we've done thus far is in any sense wrong or problematic, but it's to say that rather than simply being spectators on what is a major legal issue for the next 10 or 20 years, academics, students, legislators, all kinds of people ought to start to do some serious thinking about how do we organize ourselves to deal with enemy combatants in an environment in which a war, as Raymond points out, can go on for decades.
Let me, obviously we don't want to stay with international law forever, but it is important that part of what the United States stands for is a continued commitment to the rule of law and and it's certainly how we're perceived by others. After the last Great War, the World War II, the Geneva Conventions sought to regulate these issues, so they're not totally subjective, and there is a loud chorus of criticism, some domestically and much throughout the world, saying the United States is not acting in accordance with principles that it's adhered to in the past. Now, it seems to me that when you look at the legacy of yourself and a few other key people, the question is going to be, did you try to adhere as closely as you could to the traditions and the law that existed, or did you kind of go off in total concern about responding to the threat without regard for the rule of law? And isn't that a question that you will wrestle with intellectually and otherwise in the future?
Well, I think it's interesting that you raise that, because throughout the process that I went through in Washington and in my experience in dealing with other people in the administration, it was remarkable to me how much attentiveness was paid to issues of domestic and international law, much more so than perhaps people think when they look from the outside in on what goes on.
Why do you think there's that great disparity in perception? Because I think it's fair to say there was a great deal of criticism saying that you as a group were disregarding many settled legal principles because of your concern.
I think it's often because internal debate is handled internally, one doesn't usually conduct the debate out in public. Sometimes I think, frankly, the nuances are missed by the media. I hate to criticize the media, or simply are not noticed by people on the outside. But I can tell you, Raymond, that there were, as to all of these issues, very smart and well-educated people, well-tutored in international law as well as domestic law, who looked very seriously at every step of what was taken and offered very well-grounded judgments to the policymakers. Something that I learned from going to Washington is that there are cadres of lawyers in the Department of Defense who are experts in international law because they deal with this all the time. That's part of what you have to do in the military context.
And so the State Department as well.
And the State
Some
Department,
of whom disagreed with lawyers in the defense.
And the Department of Justice has an Office of Legal Counsel. So you had some very, very bright people who were bringing to bear their experience and their expertise on these questions. And whatever you may say, whether people agree or disagree, this was certainly, all these decisions were made with real mindfulness about the importance of controlling legal principles.
Now, Sandy says we should never deal in speculation. But going back to something she said earlier, it seems to me that one of the lines of speculation about your departure, which I think shocked many people who've been around you for many years, was that somehow in one of these policy disputes, your defeat or your victory, whatever it was, caused you to feel you couldn't stay there anymore. And I think that's one of the reasons for that little speculation.
It's fascinating to watch people speculate about things, because when you're the recipient of speculation or the object, you realize how often speculation is misplaced. I mean, my situation is very simple. There was a vacancy on the Third Circuit. The White House indicated they had an interest in my considering whether I wanted to be a candidate for that spot. I thought about it. I thought about what I wanted to do with the rest of my life, recognizing, as I said to Sandy, head of the criminal division is not and should not be a lifetime job. And it seemed to me that the place I could most make a contribution over a long term in an area that really has a lot of interest for me. So this was definitely not being my leaving, it was my being attracted to something else.
But one wonders if it isn't a sort of tame place for Michael Chertoff, who has really liked being at the vortex of the storm. And certainly you were never there more than you were beginning on September 11th, 2001. All of our lives changed that day, but your life, in terms of the responsibility that you had to have been feeling that day, the days after, the months after, had to be even more affected. As you look back now, some possibility for maybe removing yourself from the emotion of the time. How do you think that you did, and how did you handle it emotionally?
Well, it was a transforming experience for me, as I think it was for everybody in the country, and obviously more for those who lost loved ones or who were present at the scene of what happened. But I think everybody was touched in some way. But
the rest of us could just let it sink in. You actually had to do something about it.
Well, and I think one of the advantages I've had now, having been out for 7 or 8 months, is an opportunity to reflect back on a lot of what I learned. I think we face a very, very important period of time going forward. We've recovered from the initial shock. Thank God we've not had a successful attack in this country in the last 2 years. But if you look around the world, you see that there's been no they have not relented in trying to carry out terrorist attacks against Americans.
So when John Ashcroft said this week, we are winning the war on terrorism, is that accurate?
I think I view terrorism as a cancer. Management and remission are victories. Do I think we're going to totally eradicate it? No, I don't think we totally eradicated organized crime. We did succeed in curtailing it. We succeeded in reducing its threat level. I don't think we're done by terrorism, and I doubt the Attorney General has ever suggested that we're done with it. But I do think we can look back with some measure of satisfaction on the fact that for the last couple of years, we have not been the object of a successful attack. And I say that with a lot of hesitation because I'm the last person who wants to tempt fate. But if you ask me when I look at my own experience, I've come to realize how important it is that the people who make decisions in this arena, first of all, be mindful of the consequences of the decisions in the long term, but also be given the breathing space to deal with decision-making in an arena of imperfect information. I look at some of the discussion and debate now, for example, about the uses of intelligence and the misuse of intelligence. And I know from my experience, in a crisis situation with matters of life and death, people have the responsibility to make really life and death decisions with information that's at best partial or imperfect, because we don't have the human ability to know everything there is to know about the threat that we face. And we don't have the luxury of postponing the decision until we get all the information. So the question is, how do we make those decisions with imperfect information? How do we assess the risk? Do we place more of a risk on the loss of large numbers of American lives, or do we assess the risk in the other direction and take the balance of the risk, let's say, of making a mistake with respect to weapons of mass destruction? These issues are complicated, and they're worthy of debate. What I think is not good, though, is when the discussion turns into a kind of a scapegoating. Can we find an individual that we can blame because they didn't accurately predict something in the future? And I think it's important that we set forward with a mindset that we're going to learn from the past, we're going to learn from what we've done and what we haven't done, but we're going to do it in a spirit that's not blaming people, but that's trying to educate ourselves and increase our information and increase our judgment.
If you think that in this pressure cooker, scapegoating has sometimes happened at the expense of discourse, would you agree that both inside the administration and out that's tended to happen? Certainly, while there's an ongoing investigation, the question of the response to the ambassador who talked about the Niger yellow cake and comments about his wife suggests that the administration has at times contributed to what is a lack of meaningful discourse about profound issues, but also used attack and scapegoating.
Well, I don't know anything about
I'm not
that
asking you to
case.
comment about that, but certainly over time, you would assume concede that the administration has been part of the same vortex of charge and countercharge that sometimes moved away from.
I'm not even accusing people of malevolently looking to blame people. I'm saying it's a natural human tendency. When we look back, for example, at 9/11, and we ask questions about, well, could it have been prevented? There's a natural tendency for people to wonder, well, is there a villain we can identify, somebody who dropped the ball, somebody who didn't do what they should have done? And I think that I would be very much surprised if you found a person like that, because I think everybody, does their jobs, and certainly nobody would have willfully omitted any step they could have taken to prevent that disaster.
But you know that.
But what's important is that we learn. How do we make the process better? Not that we go back and see if we can find someone and pillory them on television, but whether we can learn from the process and figure out how do we make our decision-making better in the future so we anticipate and avert the next act.
Okay, but what about all the criticism that has come post 9/11 of you, of the Justice Department, of the Bush administration? You've said that there really isn't substance to the criticism. Is that right?
Well, I mean, I'm sure people get criticized for anything. Again, I want to take you back, and I think it's important.
Patriot Act. You're comfortable with it?
Well, and the Patriot Act, the funny thing about the Patriot Act is much of the criticism is leveled against the Patriot Act for things the Patriot Act doesn't say. I heard somebody 6 months ago say in television, well, the war against Iraq was authorized by the Patriot Act. Well, that's foolish. And I've frankly never heard anybody really level a criticism against a particular provision that demonstrated that it was somehow in violation of some
But let's ask somebody who would scapegoat. Do you find in the vortex all the decisions that were made, any that you could go back now and say, we should have gone another way on a fairly important decision?
That's always a hard question.
That's why we ask it.
It's hard in this sense. I can always look back and I can say, well, had I known then what I know now, I might have done A rather than B. That's the nature of human existence. The interesting and the important thing, though, is what do you do in real time, because in real time you don't have the ability to exercise hindsight. You have to exercise foresight.
And in real time, Judge Chertoff, believe it or not, our half hour is almost up. So I must ask you, you also wrote that you and the people with whom you worked would be subject to the verdict of history. How do you think history will judge you?
You know, I think I wrote in the article that I'm probably the least well suited to write that verdict because I was one of the participants. But one thing I'm very confident about is that I take a great deal of satisfaction in the fact that we have not had an attack in the last couple of years. And I hope to God that, 2 years from now and 4 years from now, we can continue to say that same thing.
That's a good way to analyze the concept of verdict. Thank you so much for being with us, because that's it for this special edition of Due Process. But we'll be back next week, and this season we're on at 3 new times: 9:30 Sunday morning, 6:30 Sunday evening, and 11:30 Tuesday night. So come back and see us next time for more cutting-edge questions of justice and law. Till then, for Sandy King and all of us here, I'm Raymond Brown, with special thanks to Judge Michael Chertoff for his rare appearance here on Due Process, and thanks to all of you for watching us.
Thank you again, Michael. Great to see you. Great to have you with us. We appreciate it greatly. Bye-bye now. Thanks a lot. Nice to see you.
I'll see you later.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,